someday, even the BPT rent to rent was by all of them. He was the ASA who swore us in actually when that is just Kanvilkar and I in 2000.
The law student might have been thinking.
Some fulmination which I then used to get TRPs. Here, I've identified 9 factors, and each of them is very instructive. He really summarizes the whole theory in my respectful submission very well.
In this article, has he identified any points of distinction in the law applicable to India and other countries? But to clear that, there are certain aspects which are distinct.
No, that's
contract as well as an more particularly contract.
My lord is right. Therefore, 487, he gave this English law is very strict, vividly, will never accept it. So they've rejected it.
That's because they have an act.
No, that is because they rely on their common law principles of contracts and peers. They jealously guard those. So they say there's no scope for an exception to those. And they see the group of companies doctrine as some kind of an exception to those doctrines. Even the US, I'm going to point out a nice article where I cited a number of theories. And Dow specifically referred to performance. Yes, absolutely. That extract from Dow, which Hanitu has quoted, it's at the bottom of it. Again, just to go back to that. Correct. The question whether persons, I presume that's the citation from Dow. Yes, Dow. The question if the agreement can take advantage of an special clause therein. It's a matter which must be decided on a case-by-case basis, requiring a close analysis of the circumstances in which the agreement is made. So making corporate and practical relationship existing on one side and moving to those on the other side of the bargain, the actual presumed intention of the parties as regards the rights of non-signatories to participate in the arbitration agreements, and the extent to which and the circumstances under which non-signatories subsequently became involved in the performance of the contract. Sure, I am correct. It's not Dow, it's some other. Dow also has similar language. It's not Dow. But there's similar language.
512 says 30th November 1998, published, unpublished. See also ICC case number.
But now there is a very strong move for publication of awards because of all this, to add some transparency. But then, of course, confidentiality is the factor that was always redact, and that is the move that most institutions are now making. So let's try the 9. First is what my lord has said. In that extract, actual or presumed intention of the parties as regards rights of non-signatories and subsequently became involved in the performance of the agreement and in the dispute. Actual or presumed intention of the parties as regards the rights of the non-signatories to participate in the arbitration agreement. And the extent to which and the circumstances under which non-signatories subsequently became involved in the performance of the agreement and in the dispute arising from it. And that's why it has to be on a case-to-case basis, because each case will be a different But which are the 9 factors? Yes, well, I have taken this as one factor, but my lord is right, there are probably 2 in here. It's intention as well as performance and dispute. So that's really 2 factors there. Then 489. A second related conclusion is that arbitral tribunals do not often base their decision to extend the clause or not on a prior determination of the applicable law. Even if they do determine the law applicable to the contract and on the arbitration agreement, that law does not necessarily play a major role in the final determination of the non-signatory issues. Starting from the principle of autonomy of the arbitration clause, arbitrators generally feel free to determine their competence according to what they consider to be, on the basis of the facts of the case, the common intention of the parties, also taken into consideration uses of international trade. So that's really the same as intention, common intention. Then 3, there is also an agreement that the existence of a group of companies is not per se a sufficient element to allow extension to a non-signatory of an arbitration agreement concluded by another member to do. This is a very important doctrine. Because often tribunals, I've found, they see a group and they say it's a group of companies. We just draw in whoever we want from that group. That's not enough. a number of other factors work on that decision. So they say existence of a group is not per se a sufficient element. Then 491. In most cases, courts and tribunals require proof of the existence of an intention, at least implicit, of all the parties, that the non-signatories be parties to the underlying contract and its arbitration clause. Some courts, however, limit themselves to an awareness of the clause and the requirement that the additional claimant or defendant be concerned by the dispute. But the company concerned must always have played a role in the conclusion and performance of the agreement, and this has to be proved by the party requesting the extension of the clause. And beyond actual or implied consent, many cases are also simply decided by reference to other theories of civil or company law, and that's the first. That is agency, piercing the veil, etc. Then 492. The analysis of the arbitral awards also leads to the emergence of a rebuttable presumption that a parent company binds its subsidiaries. But that, however, only companies that have participated in the conclusion and performance of the agreement will be bound by the contract and the arbitration clause. This rebuttable presumption is quite similar to what our Supreme Court said in Vodafone, that even if it's a wholly owned subsidiary, you still have to show control. But it's a rebuttable presumption that you will have control with your shareholding. But that's not enough. You still need to show the subsidiary participated in the conclusion and performance. Then 493. Various other elements equally play a role in the decision to extend the clause to a non-signatory. First bullet. The fact that the other party has obviously entered into the agreement with the group as a whole and did not really care which companies would be involved in its performance, assuming that the determination of the signatory companies only concerns the details of performance of the contract. That's straight from the top. He didn't care which part of the Dow group was the actual signatory because they were dealing with a number of Dow group companies. Or the next bullet point, the fact that all the companies concerned have participated in the rights and obligations of the contractual relationship, in what is sometimes being called a total contract. So there must be rights, there must be obligations of the non-signatory. He can't just be drawn in because he's part of a group. And then if we go straight to para 496, 494 refers to lifting of the corporate veil. 496, arbitral tribunals and courts have also emphasized the right to use a group structure as appropriate. But once a choice has been made, it must be fully assumed. In this respect, the use of a company vehicle for tax or other reasons is not per se an argument to justify lifting the corporate veil. And for example, extend the arbitration, very much part of our law. As I said in Azadi Bachao, Vodafone, they all respected this. If there's fraud, circumvention, of course, but not otherwise. And then 497. It seems that at least in a number of cases, a good test to decide whether an extension of the clause is appropriate is to determine whether the same solution would be justified if the situation was reversed. In other words, it is tentatively suggested that the principles used to determine the eventual extension of the clause to additional defendants might also be applied with some caution, however, when the case concerns additional claimants and vice versa. In fact, in Dow, it was the non-signatories who sought to be joined as claimants. So when a tribunal says, group of companies doctrine, this company A, we are joining as a defendant, it must apply its mind. Would we have allowed it to come in as a claimant? Same test must apply. And it has to, because even when you bring in a defendant, there can always be a counterclaim. So it has to be a reciprocal test. It can't be that you just look for the most asset-rich company of the group and go for it. Would you have allowed that asset-rich company to have filed a claim against that claimant? That's a good test. None of these, it's not, he doesn't say that each and every one of these factors has to be met. But he certainly suggests that a large number of these have to be met. And merely being part of a group is not enough.
No, I didn't
actually, I'm not sure whether performance in all cases is necessary, because it could be that, a party, for instance, says that, look, you entered into a contract with my subsidiary. I'm the developer of the software. I'm the creator of the technology. And therefore, my subsidiary is basically going to be selling you what I have created and I have developed. So the third party who enters into the contract, the contracting party which enters into a contract, relies on the representation which was held out by the parent. Eventually, the parent may just step back and say, "Look, I am not participating in the contract."
Yes.
So the claim really is for breach of the representation.
Correct.
Then, in which case, the fact that the parent did not participate in the performance of the contract may not be itself very
correct. But therefore, that's where, in fact, there's a good article which my father
So these are circumstances. In mind, I'm not sure whether they should be treated as cumulative, because then we'll be actively
No, of course not. Of course not. That's not the submission. But a large, the test is really, does it meet the contract act threshold for implied? If it does, then the contract. It may be that in a given case, just one of these is enough to constitute implied acceptance. It could be. But it must ultimately meet that the test of the Contract Act Section 7 with 30. Was there an intent to unconditionally accept the arbitration agreement? That is the main part. Because what is also now happening is another complication. Parties are being joined to arbitrations on the footing that they are parties to the arbitration agreement. But the question of liability under the main is left open. So you may have a situation where you join a party, participates in an entire arbitration, having to read evidence, etc. And at the end of the day, it's found that the contract doesn't hold them back to anything.
So, Mr. Khambata, the first point which we identified was the actual or presumed intention of the party as rights of non-signatories to participate in the arbitration agreement. The second was participation in the execution of the contract.
Yes.
Third was participation in the performance of the contract.
Yes.
Which are the other features then?
Yes. The second is performance and in the dispute also.
Participation in the performance
and dispute. There must be some, as my Lord said, the dispute must be that you made the representation to me. Therefore, that is the dispute. It can't just be. Because equally the flip side is.
There's a third. Then what else?
Then if you go to the next page, para 49. Just because there is a group of companies is not per se a sufficient element on its own. Then 491 really goes back to reiteration of performance, role in performance. That we've seen. But if we see 492, the fifth factor, rebuttable presumption if it's a subsidiary. But provided that subsidiary participated in performance of the contract. Then 6 and 7 are found in paragraph. That the party did not consider or care really. That's the example that fell from my law. That it's a group, you're really dealing with the essential party, you don't care who actually signed. But that has to be proved. It can't just be us. Then 7 is that all the companies concerned have participated in the rights and obligations of the contractual relationship. That's the underlying contract. Must be rights and obligations. My Lord has referred to a theory of estoppel, the benefits estoppel theory in America. So if you get benefits, then you are estoppel. But here for a group of companies, it's rights and obligations. Both of the underlying contract. Then factor 8 is in para 496. The right to use a group or corporate structure. That is respected. It's not that is just overridden. Because you may, with open eyes, contract with a